contending parties, to which Masters Adejo and Governor Yahaya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 96, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded. End of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their vehemence were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellants ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A. specify the parties interested in the petition, in the election petition. B. Specify the right of the petitioner to present the election petition. 3. State the holding of the election, the scores of the candidates, and the person returned as the winner of the election. And 4. State clearly the facts of the petition and the ground or grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram partem rule, to prevent surprise or ambush on the defendants, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Econife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought and not evasive or vague so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16 sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondents who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134 sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score, to rebut the results put forward by the INEC. The law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably their counsel should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cause, but affirmed the judgment of the lower court, declaring the second respondent, Bola Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February, 2023. Thank you.
My learned brother to my immediate left will deliver his judgment.
The lead judgment just delivered by my learned brother Okoro JSC has comprehensively presented all the points I made and the views I expressed at the conference of the Honorable Justices of this panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issues, both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, is, with respect to Chief Uche Ezean, spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court would make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because Learned Council representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective Learned Council that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ijeoma Egwuatu, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ijeoma Egwuatu, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Ijeoma Egwuatu, JSC-CFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court? Because of the peculiar circumstances of this case, and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the District Court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said District Court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the District Court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. The view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in the election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord.
Hello there, this is the World News at 12 on Voice of the People, 90.3 FM. My name is Ijeoma Innocent, and these are the top stories. Supreme Court rejects Atiku's motion to file fresh evidence, affirms Tinubu's election in live transmission of final ruling on 2023 presidential elections. Ethiopian Airlines reveals the federal government insisted on painting its aircraft for Nigeria Air unveiling. Former EFCC chairman Bawa released after 5 months, and the Odo State Deputy Governor begs Akeredolu. On the foreign scene, Russian President Putin accuses West of using religious hatred to destabilize the world. Details now. Thank you for staying with us. The World News at 12 begins with the Supreme Court giving its verdict in a live transmission of today's final judgment on the outcome of the 2023 presidential election. VOP News gathered that the Chief Justice of Nigeria, Olukayode Ariwola, approved the live transmission of the Supreme Court judgment. The Supreme Court today ruled that the application to file fresh evidence by the People's Democratic Party (PDP) candidate Atiku Abubakar in the appeal challenging President Bola Tinubu's victory runs foul of the provisions of the Electoral Act. The court held that the Electoral Act prohibits the amendment of an election petition in such a manner. Justice John Okoro held that the Supreme Court cannot activate Section 22 of the Supreme Court Act after 180 days has lapsed at the lower court. In reading his judgment, Justice Okoro chose to first determine the merits of the motion by Atiku and the PDP to supply fresh evidence in the form of documents obtained from the Chicago State University (CSU) on President Bola Tinubu's academic records. He highlighted the importance of ascertaining whether the nation's law allows the court to accept fresh evidence at this stage of the petition. After going through the motions, the lead justice on the 7-man panel, Justice John Okoro, affirmed Bola Ahmed Tinubu as the rightful winner of the February 25 general elections and as Nigeria's legal president. Well, now joining me to discuss this on the World News at 12 this afternoon, we have barrister, law legal practitioner, Barrister Evans Ufeli. Good afternoon, Barrister Ufeli. Thank you for joining me.
Good afternoon.
It's always a pleasure to have you here. Let's talk about the Supreme Court ruling, which is still underway. Other judges are also, giving their own verdict as well. But the head of the panel has given his judgment. Well, before getting to the point where they said, Bola Tinubu is affirmed as Nigeria's president, they upheld most of the judgments of the lower court. That's the Presidential Election Petition Tribunal, the appeal court. The judge ruled that the Supreme Court, that's the apex court now, found it ridiculous, the submission of Atiku's counsel, that the 180-day rule does not apply to the Court of Appeal sitting on the Presidential Election Petition. He said even an application to amend their petition to accommodate the fresh evidence could not be granted. While reading the judgment, Justice Okoro said that the application was filed after 180 days prescribed by law lapsed. Now, we know that so much ado was made about this CSU certificate issue. It was such a scandal. It pervaded the media for so many days, and we talked about it a lot, hoping that the Supreme Court may uphold it. But many critics have said, look, 180 days has lapsed. No matter the weight you think this evidence carried, it cannot be admitted. As a legal practitioner who has more knowledge of these matters than we do, all the listeners would like you to weigh into this issue.
Yeah, the truth is that at the tribunal stage, the tribunal have 180 days within which to determine the case. However, in the case under reference, all the evidence of parties and their depositions were determined within the 180 days. So there's a sense in which if you are bringing a new evidence, the new evidence will mean that that evidence is supposed to count in for the court, the Court of Appeal, the Supreme Court now, but that evidence is supposed to have been tendered by the first court, which no longer have jurisdiction. So bringing it at the Supreme Court is based on the discretion of the Supreme Court. We have said this before. The Supreme Court have now, one of them have now given its own ruling to the effect that the issue of 180 days is very critical. That you cannot activate that evidence by Section 22 of the Supreme Court when the evidence did not come in within the 190 days that the lower court is supposed to determine it. When records are transmitted from the lower court to the higher court, it is what the lower court did that the higher court will determine on appeal. So this fresh evidence was not part of what was transmitted. And with that, I had that fear that this evidence may not be admitted. May not be admitted in the sense that it is statute bar to admit it. Even though Section 22 of the Supreme Court Act gives the Supreme Court the right to rehear a matter, but it's anchored on the discretion. So I think that is why the admission of that evidence failed. And assuming but not considering that the evidence even passed the test of time, it went in. You look at it, you find out that one of the evidence is saying is authenticating the fact that the president attended this one. The other is saying a different thing. There are divergent, two evidence of divergent submission and views. The court will not even admit anyone. Even if they admit it, it will not rely on it. There appears to be a very bad case for Atiku. Because if you look at the long-touted evidence itself, one was authenticating Bola Tinubu's studentship. Another was saying the result in Somalia was not the one. So the evidence, even if I were to read, I would have even admitted the evidence. But then the quality of the evidence is divergent. In law, when you have two evidence, one is saying go right, one is saying go left on the same issue, the court will not rely on anyone. So that is how that is. So even if it is admitted, that evidence itself have a very defective compartment that would have been very difficult for the Supreme Court to rely on me to pronounce people the winner of that election or disqualify Tinubu as president or as one who was never qualified to contest the election.
All right then, Barrister Ofeli. Now, with what you've spoken about, before they got to this point, Atiku's motion was rejected to file fresh evidence, right? Now, let's go to the issue of scoring 25% of votes in the FCT, which was one thing that was also brought up as well. And the Supreme Court ruled, following what the appeal court, the Pepsi, also said, that 25% of vote is not mandatory. He said, Justice Okoro said, and I quote, "Are you saying if someone scores 25% of vote in 30 states, but not in Abuja, he should not be president? Is that how you interpret the law?" He says that is not the law. The Supreme Court agrees with the Court of Appeal. I'd like you to also wade into that.
Yeah, the Court of Appeal has said that Abuja does not have a special status. You understand? That the intent of the lawmaker is not that if you win everywhere and you don't win 25% in Abuja, therefore you will not become president. That it couldn't have been the law or the intent of the legislature. And then the Supreme Court is coming back to restate that fact. Because if you advance that argument, and you must get 25% of Abuja, I think if you win all the states in Nigeria, if you advance the argument, you are going to end up with a very effective outcome in terms of the fact that you are not the argument is even apartheid. The argument is great inequality. So what you are saying is that there's a particular area of the country that is better circumstances, better that's all you're saying. So I have seen that the major thing that is required is for you to win as many states as possible. Okay, to at least 25%, 25% of 24 states. You understand? 25% of 24 states. But at the angle of including FCT, because again a compulsory anything, then that's important for the process of that. Okay, so if you have that, can it be canvassed anywhere that because Abuja is not there, therefore that argument is not a sound argument. It's not a sound argument because it's the democracy. Democracy has to do with numbers. Okay? You win more seats, more government, more states. So just because you don't win Abuja, then it's not the right interpretation for me. It's not the right interpretation. But I on the first issue, I would have thought the Supreme Court would have administered that question. If I were to be in the Supreme Court, I would have ensured that it's admitted. But even if it's admitted, I know that the quality of the evidence is not good too. And the school have to, so somebody deposing an affidavit on another issue, the school issuing a letter on two divergent views on one issue. It don't work.
All right then. One more thing the Supreme Court says is that it lacks the jurisdiction to hear Atiku's case. After coming from the Pepsi to the Supreme Court, if the Supreme Court is saying it lacks jurisdiction to hear Atiku's case, then where else could Atiku have taken his case to?
It lacks jurisdiction with respect to the new evidence. You know, that evidence ought to have been tendered within 180 days during the tribunal. That was what he said. That was what he said. So that one bringing it now when the 180 days have made it statute bar. That is what I was saying. So because not saying it does not have jurisdiction in its entirety, but the jurisdiction to admit the evidence that is tendered at press. When in the layers of nature and Justice Ogunchade said that the 180 days cannot be elongated, cannot be moved. One further says that it's like the rock of Gibraltar or Mount Zion, like a rock station. So if it cannot be moved, once the 180 days lapse, whatever you not bring in within the 180 days, you cannot smuggle it into the case on appeal. That's what everybody is saying. You cannot smuggle into the case on appeal. So that is where the issue of jurisdiction of the Supreme Court, the Supreme Court is talking about.
All right, Barrister Ofeli. Let's talk about just like you said, the issue of jurisdiction. Now, one thing the justice of the court also said is that election results are deemed to be correct until they are proved otherwise, and that the burden is on the petitioner to provide evidence. Now, he said that the appeal also lacks merit, it is frivolous and vexatious. He spoke about the deposition, which is the evidence now, the new fresh evidence that Atiku wanted to be admitted. He said a deposition from another country should have the seal of the court or the signature of an authorized officer. He said the deposition that was brought to the Supreme Court was not authenticated and could not be admitted in Nigeria, in any Nigerian court, without authentication. Would Atiku really have gone through all the trouble of providing this evidence and then tendering one that could not actually stand, we call it the test, one that is not authenticated as well?
Yeah, that is him ruling his case now. If he has gone all over to the United States to procure the United States, why tender the one that is not authenticated? If you have the genuine evidence, and at the point of filing, you want to tender the one that is not authenticated, you are the one ruling your case now. It's not the Supreme Court now. So the Supreme Court should not be blamed because the Supreme Court don't know whether you have the right one or the wrong one. The one you tender is the one they worked on. And they have acted on it to the fact that it's not authenticated. It's not authenticated. The petitioner shot themselves on the foot for not doing the right. I know Nigerians don't like this commentary I'm making on this afternoon, but the truth, I think the right commentary to be made in the circumstance, because if you have procured evidence, if you look at section 133 of the evidence act, it is that you want a court to admit the existence of the document was proof that document exists. And if you have gone as far as proof that document exists, you will need to do everything within the law to ensure that it's admitted. Okay? So when you don't do everything within the law and it's not admitted, it's no longer the Supreme Court now. You shot yourself by presenting one that's not authenticated. So you see, the court have no emotions. So the court, there's nothing like let us help them to. Court don't operate like that. If you are not prepared, you are not prepared. If you are prepared, you are prepared. That's what the court is.
All right, then let's talk about INEC and IREV. The Supreme Court also held that non-transmission of results on the IREV portal did not affect the outcome of the polls at all. The court, just dismissed. But then it ruled that the failure of INEC to transmit the election results on the result viewing portal did not affect. The judge said, and I quote, when IREV fails, it does not stop the collation of the results. It only deprives people of viewing results. The non-function will affect the trust of the electorate in the election. Now, one more thing that the judge said was that the petitioner's witnesses' reports were mostly hearsay, as there was no forensic report to substantiate reports of maybe double thumbprinting by polling agents of other parties. He said one petitioner only visited 19 polling units, and evidences of many collection agent reports that polling agents was that the polling agent functioned well. So why are they saying there were issues of double or more than double thumbprinting? Said many collection agents could only testify for their own units and not other polling units that they did not visit because they are not experts. Now, we do know that INEC said results to be transmitted in real time. The Supreme Court ruling that, whether or not it is transmitted in real time, since IREV is only a result viewing portal and there were manual collation of results. If you notice during the elections, then there were several cases, we saw several pictures of collation sheets where results were cancelled out and were rewritten. Is this not evidence enough?
Yeah, it is evidence. But the truth is that all those cancellations and the alterations and all that, the burden of proving that they were malpractice lie on the petitioner. The petitioner needs to prove what ought to have been there that was cancelled to be what is there now. Do you understand me?
I'm with you, Barrister Ofeli.
The petitioner had always said that there were irregularities and substantial non-compliance with the Electoral Act. But in those occasions and figures from AC and all that, the petitioner did not state what should have been there that was not there, or what was supposed to be written that was cancelled to be something else. So you see that burden of proof was not discharged. And the burden of proof had been discharged by the witnesses. Okay, effectively, every sheet of paper, they would have proven their case in that regard, but they have implanted the view of analyzing the issue. They just say that there were irregularities. Some votes of this candidate were taken and given this candidate. They won't give you how many local governments, how many polling units, how many states were affected. Even if it's the whole country that was affected, they are supposed to prove it. They are supposed to show you to record that in the 36 states, in state, in Adamawa state, this is this and this and this and this. They put down in Abia state, this local government, polling units, and all that. That's how you take it state by state until you finish and prove that irregularities occurred. But if you just come out and say they just take from here, put here, and then that is no court will believe that kind of thing. Court doesn't work like that. You have to respect it.
All right, then let's talk about the Labour Party. As regards President Tinubu not being eligible to contest the election, the judge said the Labour Party could not prove their case of forfeiture and drug dealing against the president. Said the LP brought the evidence when they had lost their time to reply, and that that's when it was their time to plead the case. It had already passed, and the other side needed to be held. This is not something that happened now. It's an information that is in the public domain. All in all, I'd like to know how you weigh into this particular judgment right here because we had the one on the PDP that's not admitting fresh evidence in the case of Atiku, because that's what Atiku went to the Supreme Court for. But now in the case of the LP, how do you see this judgment?
Yeah, the area that I talk about the issue of conviction, being convicted based on the constitutional provision on disqualification or qualification. It has been made clear that it was a civil forfeiture that Tinubu was involved in and not a criminal case. And the Supreme Court has affirmed it. You see, because if you are proving that this guy was convicted, you have to, as a matter of fact, in your proceedings, you must plead the charge sheet where he was arraigned. The charge sheet, you must also plead maybe record of proceedings, showing how the proceeding went. I must plead the judgment that incorporated him, or the judgment that said that he was hereby convicted of a criminal offense. And possibly you plead the document showing that he has served a term of imprisonment and was convicted. None of these documents mentioned so far was brought before the court. None. The other side, the Tinubu side, argued that it was a civil forfeiture of the fund that transpired, and that does not amount to a criminal conviction. Okay, and that is what the Supreme Court is speaking to that effect. So, it is what it is. The court may not have given people what they want or what they want to hear, but the truth is that the court cannot change its rules, or it cannot change the procedures of law in order to make the public feel good about themselves or their situation. The candidate that alleges must prove. And if they are falling short of that, because what we want is that we want the court to change the rules. We want the court to change the rules today because we are on the other side. We want somebody to go down. Forgetting that tomorrow we'll be at that other side and the rules would have turned. We will not be asking the court to go back to what it was before. It won't work like that too.
All right, then let's still go back to the case of 25% in the FCT. Where did the misunderstanding or the initial misinterpretation or misrepresentation? If the Supreme Court and the Pepsi is upholding that, scoring 25% of votes in the FCT is not mandatory. In fact, the appeal court held that the FCT will be treated as just another state. Where did the misinterpretation come from?
Well, Well, the misinterpretation came from the fact that people are reading the law without understanding the right import of it. The law should be read together with the interpretation section. If you look at section 290 of the Constitution, it clearly states that for the purpose of election, Abuja is not like any other state. You understand? So the reason it single out the FCC is because the FCC is not a state in the making of law, but a federal capital territory. So being a federal capital territory, the Constitution has to give it a status when election arises. That's why in section 290, it stated it there that for the purpose of election, Abuja shall be regarded as a state. And that suffices. So it becomes one of the states in the process, and no state have a special status. So those who misread it, or the intention of the legislature is not actually that 25% outrightly. So if we contest election and one person wins 25 states only, 25% only in Abuja, and didn't get any vote in any of the other states, so that person should be the president. Is he going to be the president of Abuja, or the president of Nigeria, or the president of 25%? So this thing is very clear.
All right then.
I know why the thing sounds like this. People want it to go the other way around, but those who want to go the other way around don't have the right legal argument to have it delivered that way.
All right then. Are you with me, Barrister Evans?
Yes.
Thank you. Thank you so much for joining me on the World News at 12 this afternoon. I really appreciate your presence, your input, and your analysis. You've thrown legal perspective, more legal light on the issue, and I appreciate it so much. Thank you so much, and have a wonderful day.
Thank you.
The Group Chief Executive Officer of Ethiopian Airlines, Mr. Mesfin Tasiu, has provided an insight into the involvement of the East African airline in the setting up of Nigeria Air, saying the airline almost withdrew, but the government insisted it should continue with the process. This is the first time the Ethiopian Airlines leadership would speak on the controversy over the airline, which dogged the last minutes of the immediate past administration. Former Minister of Aviation, Senator Hadi Sirika, had floated the airline on May 27, which did not see the light of day, as it was later discovered that the plane belonging to ET was used to conduct a demonstration flight against the dictate of the process for the establishment of a new airline. Speaking with some Nigerian journalists in Addis Ababa, the airline CEO stated that the East African carrier never had any plan to set up an airline in Nigeria, but was invited by the federal government to partner with it to establish a national carrier. It also explained that the federal government requested that the Nigeria Air logo be painted on the Ethiopian Airlines aircraft for inspection, and the airline agreed. In the meantime, the immediate past chairman of the Economic and Financial Crimes Commission, EFCC, Abdulrasheed Bawa, has been released 5 months after detention. You will recall that Bawa was arrested by the Department of State Services, DSS, on June 14, hours after his suspension from office as EFCC chairman by President Bola Tinubu over alleged abuse of office. Meanwhile, the former EFCC chairman has reportedly sued the DSS for his detention. Before he is released, Bawa had filed a suit at the Lagos Division of the Federal High Court for the enforcement of fundamental rights by a lawyer on his behalf. The former EFCC chairman sought an order from the court to declare his detention without trial illegal and to order his immediate release. Elsewhere, the Deputy Governor of Ondo State, Lucky Ayedatiwa, has apologized to his principal, Governor Rotimi Akeredolu. The embattled Deputy Governor tendered his apology when addressing the World Press Conference today. Ayedatiwa called for an end to what he termed needless crisis in the southwest state. According to him, he was saddened by the embarrassment and discomfort due to the barrage of negative news over the crisis in the last few months. The deputy governor said there were no issues between him and the governor, but political actors had capitalized on Akeredolu's absence to create crisis for their selfish interest. On the foreign scene, Russian President Vladimir Putin has accused the West of fomenting religious hatred and intolerance to divide and conquer the world, to maintain a new world order that amounts to dominance and colonialism. He warned that these forces want the epidemic of violence and hatred to engulf not just the Middle East, but Eurasia. Putin, in a message with leaders on Russia's religious communities at the Kremlin on the current conflict in the Middle East, warned that Islamophobia, anti-Semitism and Russophobia were being used as weapons against a multipolar world. Putin expressed condolences to all Israelis who lost family members in the October 7 attacks, but warned that innocent people should not be held accountable for crimes committed by others, and that the fight against terrorism cannot be carried out according to the notorious principle of collective responsibility. And that's it on the World News at 12. Just before we wrap up here, let's take a look again at the top stories. You heard that the Supreme Court has rejected Atiku's motion to file fresh evidence and affirmed President Tinubu's election in a live transmission of a final ruling on the 2023 presidential election. Ethiopian Airlines have revealed that the federal government insisted on painting its aircraft for Nigeria Air unveiling. The former EFCC chairman Bawa has been released after 5 months, and the Ondo State Deputy Governor has begged Governor Akeredolu. On the foreign scene, the Russian president has accused the West of using religious hatred to destabilize the world. And that is a wrap on the World News at 12. My name is Ijeoma Innocent. Please follow our social media handles at VOP903FM. For coverage of your live events and brand news mentioned on our news bulletins, do send a mail to news@voiceofthepeople.ng. Good afternoon and thank you for listening. Please stay tuned. Matters comes up next.
To the best exclusive radio station, VOP 90.3, bringing you the best mix of the best music. Who plays? Oh yeah, this is VOP, baby. Welcome to the best exclusive radio station, VOP 90.3.